It's the appointed time. We have a quorum. So this is our third meeting of the subcommittee. We welcome the officials joining us. So let's continue the scrutiny of the subsidiary legislation. We are at section 12 and we are at the questions and answers session. Mr. Chen Xiu-Hong. Thank you, Chairman. So this is the offense about resisting or obstructing an officer from the OSNS. So I just heard the explanation of the government. The public is well aware of the concept of obstructing or resisting a public officer in performing their duty, but then people know next to nothing about the identity documents of an officer from the OSNS. So I'm thinking, in the early days, when the OSNS officers start enforcing the law, they start to perform the duties, there is a chance that the public thinks such officers may be someone posing as an officer, and there may be some kind of obstruction or resistance, and then people will have to take steps to verify, and then they realize they have come across a real officer. But some kind of obstruction or resistance will have taken place in the process, and then the judge will have to make a decision. So that will hinge on whether the person accused of such a crime has an excuse. Then I don't see any defense under section 12. So there shouldn't be any defense for people acting willfully. But then there are people maybe acting because they think someone is posing as an OSNS officer in good faith. So my question is, I know I may be laboring this point, but I think this point is top of mind for people, so I just want to ask the government what to do when that happens. So, Secretary for Security, when we say willfully, we're saying someone who doing something on purpose. If you think someone is posing as an officer and you refuse to cooperate, that makes sense. So in this case, there is no willful element because you don't believe that person to be a real officer. Anything to add from the Secretary for Justice? Mr. Tang is right. When we say willfully, we're talking about knowledge. So you know or you think this person is an officer. You know this is an officer, but then you decide to obstruct the officer. So that's what we mean by willfully. And this is well established in case law. So in that case, no criminal offense will arise. So you're saying that person can raise this as a defense. But this person will have to show that they truly are ignorant of the fact that it's a real officer. They cannot simply claim ignorance. They have to verify their claim. But if the facts are such that this person really has no idea they are dealing with a real officer, then we cannot say this person willfully obstructed the officer. Mr. Holden Chow, I'm looking at section 12b. I just heard a clear explanation. So for the average person, they have nothing to worry about. They can simply verify the identity, and verifying the identity of this officer will not amount to obstruction. Now my question is, what if you really have someone with ulterior motives? Let's say this person willfully obstructs an officer, and this person asks other people not to cooperate with the officer. Say this person knows an Article 55 investigation is going on, and this person asks others not to cooperate with the officers and actually tells other people to flee the scene. And this happens outside Hong Kong. I don't see extraterritorial effect for this provision. So I'm saying, when the scenario I just raised happens, that person won't be caught by this scenario. I'm saying, what if someone with ulterior motives deliberately asks other people not to cooperate with the OSNS and even tells people how to flee. And if this happens outside Hong Kong, so is it right that we won't be able to catch that person with this provision? Secretary, so this section has no extraterritorial effect, and this provision only applies to the work of the OSNS in Hong Kong. Mr. Tony Teh. Thank you, Chairman. Now, from what I know, assaulting a police officer or obstructing a police officer can be punishable by up to 2 years in jail. Here, we're talking about national security offenses. It's a serious offense, so the maximum imprisonment is 3 years. I think that's appropriate. Now, for obstructing a police officer, you can prosecute someone under the Summary Offences Ordinance. But here, we're talking about conviction on indictment. But can we also take the summary route here? Of course, that will lead to a lower penalty. Mr. Ivan Leung. Now, all offenses under this subsidiary legislation are indictable. But we're not saying it's High Court only. Last year, when we were looking at the bill for the SNSO, we also brought up this point, and there was an amendment to the Magistrates' Ordinance. Simply put, at the Magistrates' Court, at the District Court, and at the CFI of the High Court, all those courts can deal with indictable offenses under this legislation. As for the penalty handed down by the court, those courts will be able to hand down a sentence only in line with the jurisdiction, so it's 2 years maximum for a magistrate's court. Legal advisor. Thank you, Chairman. I have a related question. So let's look at Section 12. The maximum fine is $200,000 and imprisonment for 3 years maximum. Let's look at some penalties under existing ordinances about obstructing or resisting officers performing their duties. Take, for instance, under the Prevention of Bribery Ordinance, there's a provision that says there's a penalty for obstructing an ICAC officer. The fine and the imprisonment are lower, so $5,000 in fines and 6 months in jail. We do realize we are talking about obstructing officers dealing with different matters. So can the administration explain to us what factors were taken into account in drafting Section 12? What factors led the government to believe that this fine and imprisonment levels are appropriate? So this is more of a policy question. Secretary for Security. So we look at the cases dealt with by police officers and those dealt with by the OSNS. The OSNS deals with national security cases. Such cases are more serious than those handled by police officers. So the gravity of the cases is a factor we consider. Mr. Ivan Leung. Now, on this offense about obstructing the performance of duties, we have looked at our local ordinances. We looked at the imprisonment and the fines. Actually, the penalty levels vary from one ordinance to the next. In some cases, it's $5,000 in fines, 6 months in imprisonment. But when you look at Section 36 of the Offenses Against the Person Ordinance, obstructing a police officer, the maximum imprisonment is 2 years. And there's no specific fine level, meaning there's no maximum fine level for that offense under Section 36 of Cap 212. As the Secretary and the Deputy Secretary just said, obstructing an OSNS officer is a more serious offense. So we are proposing maximum 3 years imprisonment for this offense, which is higher than obstructing a police officer. the thinking is that the maximum penalty in terms of imprisonment is 7 years, maximum fine being $500,000. Now, since we are proposing maximum 3 years of imprisonment for this offense, we are proposing lower levels for other offenses under this regulation. There are obstruction offenses that also come with a high level in fines. Take the Securities and Futures Ordinance as an example. The SFO deals with institutions, organizations that may have breached the SFO. You cannot imprison an organization. That's why the SFO imposes fines up to $1 million or $500,000. But in this case, this regulation may deal with people or organizations. That's why we set the fine at $200,000. Ms. Khan, I have a question about the point raised by the legal advisor. I wonder, now for the ordinance, the Prevention of Bribery Ordinance, I think the fine is level 2 in fines and also imprisonment for 6 months. For that offense, the element about willfully is absent. I'm thinking maybe it's because of the absence of willfully in that offense, and that's why the penalties are lower. The DOJ has just explained that for this offense under this regulation, willfully is a key element. That's why different considerations apply for the penalty levels. So is this correct, legal advisor? The member is right. Section 13A of the Prevention of Bribery Ordinance is indeed an offense that comes without the willful element. This is a key element, and the government can supplement the response if needed. The willful element aggravates the offense, and that's how we can make sense of the provision. Let's see if the government has any response or supplement to the member's comment. Mr. Ivan Leung, I have nothing to add. So we have taken into account all these factors, and we have considered local ordinances and also the points I just raised. Mr. Chen Xiuhong, were you going to ask a question about this? Many people worry that scammers posing as OSNS officers may try to defraud them. And people get a call by someone who claimed to be an OSNS officer. They get the first call, they just hang up. But when scammers call people repeatedly, and then the public may worry they may be committing the offense of obstructing or resisting an OSNS officer. So we have the anti-scam helpline 1-822, and also we have 999. Can people call these two numbers, or are there other channels for people to tell that a call is indeed from the OSNS? Are there other ways for people to get help? The member just mentioned 1-822 and 999. As long as people get in touch with the police will help verify whether this call is for real. Scammers can call people repeatedly, so we shouldn't be relying on the number of calls to tell whether a call is from a scammer. What you need is tools. So if 1-822 and 999 can help people tell a scam call from a real call, that will be helpful. So that's an opinion from the member.
Deputy Secretary, thank you. Section 13. Person pretending to be staff member of the OSNS may give rise to severe consequences. In order to protect the legitimate interest of the people, we provide for an offense of falsely pretending to be or be able to influence staff member of OSNS. There are two subsections to it. First, if a person by an act or omission, and whether or not with intent to procure any valuable thing, falsely pretends that the person is a staff member of the OSNS or is able to procure a staff member of the OSNS to do or refrain from doing an act relating to a duty of the staff member, that person commits an offense and is liable on conviction on indictment to a fine of $200,000 and imprisonment of 3 years. 2. In other proceedings for an offense under subsection 1, it is presumed unless the contrary is proved that the defendant was not a staff member of the OSNS at the material time. Questions? Deputy Chairman. People may commit an offense inadvertently. Because under section 13 bracket 1, if it says if a person can influence a staff members to do or refrain from doing an act, then they may commit an offense. What is the ground for that? If, say, I'm arguing with a person, I may threaten them by saying that I will ask the OSNS to arrest them. Then I may be pretending to be able to influence a staff member of OSNS to do or refrain from doing an act. So out of anger, a person may falsely pretend to be an OSNS staff or be able to falsely claim that they are able to influence them. So can you let us know what conditions we have to fulfill in order for us to be charged with such an offense of falsely pretending to be or be able to influence staff member of the OSNS? Secretary. Well, we have to look at the circumstances of a case. Say, for example, we may threaten a child by saying that we will ask the police to arrest them if they don't eat. This is obviously not the truth. However, if I say that if you don't do business with them, I may ask the OSNS to arrest you, we have to look at the context and the possibility of such from happening. Mr. Yang Wen-kit. Thank you. I'd like to follow on also section 13 bracket 1. If a person by an act or omission, and whether or not with intent to procure any valuable thing, pretends to be a person, pretends to be a staff member of the OSNS, it's easy to understand. But what does it mean by omission? How can we pretend to be a OSNS staff by omission? I can give you an example. Say, for example, if a person requests information from you and they say that, I'm from a powerful authority, you may ask them, are you from the OSNS? Even if that person does not explicitly say that they are from the OSNS, but take actions or say things that mislead people into believing them that they are from the OSNS, then that will constitute an omission. Mr. Jeffrey Lam. People pretend to be police officers, OSNS staff, liaison office staff, mainland authority, officers online. You will definitely commit an offense if you pretend to be OSNS staff. But these scams don't happen usually in Hong Kong. Sometimes scammers are overseas. We have conspiracy to defraud, deception, use of false documents, and offenses as such. After this bill is passed, if someone falsely pretend to be an OSNS staff, will they also be committing offenses under other legislation, such as conspiracy to defraud? Will that person be charged with all of these offenses together? How can a person verify the identity of a OSNS staff if they are contacted by them? A person may try to seek help from the police, but the OSNS staff may conceal their identity. When they're carrying out their duty, they may not disclose their identity to the police. How can a police officer verify if someone is actually from the OSNS? And in the process, if we inadvertently obstruct the OSNS staff in the execution of their duty. What happened? Secretary, this section does not have extraterritorial effect. If someone deceives others out of money, and if they assault someone while pretending to be an OSNS staff, we can invoke other legislation, such as offenses of deception, of assault, of pretending to be a public officer. We will charge that person with all of these offenses if the case can be substantiated, and the person may be subject to different level of penalty. The police and the OSNS work together very closely. You do have a mechanism to verify the identity of an OSNS staff, so if you have any suspicion, please call the police. The legal law enforcement officers have the duty to assist OSNS in the due execution of their duty. And sometimes the OSNS may ask police officers to do crowd management for them or carry out other duties. And I think by this it will alleviate people's concern. Ms. Carmen Khan. Thank you, Chairman. I have a very simple question. It says, whether or not with intent to procure any other valuable thing under subsection 1. Do we have such a phrase in other similar legislation? So does it mean that whether or not a person gain from such an act, they may still commit an offense if they pretend to be an OSNS staff? Under subsection 2, there is a presumption. Does this exist in other similar legislation as well? Secretary. Or rather, Mr. Leung. Thank you. We have made reference to the Summary Offences Ordinance, Section 22, pretending to be a public officer. Pretending to be a public officer is a serious offense. So whether or not you pretend to be a public officer in order to gain anything, that's not important. If you deceive someone by pretending to be a public officer, you may be charged with other offenses. Regarding the presumption in subsection 2, what function does it serve? Well, if the prosecution have to prove that a person is not an OSNS staff, then we may have to obtain a list of OSNS staff in order to substantiate if someone is not an OSNS staff. This is a complicated procedure, and that may not be appropriate. So same goes for the Summary Offense Ordinance. If the defendant claims to be an OSNS staff, then they should prove that they are a staff. Otherwise, we should presume the contrary. Dr. Lo Wai Kwok. Thank you. The administration said that this section does not have extraterritorial effect. However, many online scams come from people from other countries. So can we invoke other legislation to deal with deceptions involving scammers from other places? Because otherwise it may give rise to misunderstanding. Secretary for Security. If any parts of the case happen in Hong Kong, we have the jurisdiction over it. Although this offense does not have extraterritorial effect, if the scammers come from other countries and you make the payment in Hong Kong, then we can still invoke other legislation. So my understanding is correct. We may not invoke this section. We can invoke other legislation to handle cases of deception. If any part of the case happens in Hong Kong, then of course. Thank you. Next section, please. Thank you, Chairman. Section 14. offense of forging documents, etc. of OSNS. 13 is about falsely pretending to be an OSNS staff. 14 is about offense of forging document. There are 4 subsections to it. Subsections 1 and 2. Well, subsection 1 is about the act. There are 1A, B, C. 1A forges or falsifies a document or any other thing specified in subsection 2. B knowingly uses a document or any other thing specified in subsection 2 that is forged or falsified. Or 3C knowingly possesses a document or any other thing specified in subsection 2 that is forged or falsified. So subsection 1 is about an act. Subsection 2 is about documents and other things. There's 5 types of it: a seal or signature of the OSNS or staff member of the OSNS. B, a legal instrument. That is, legal instrument issued under Article 57 of the NSL. C, that's in relation to Section 11 of the regulation, an identification document or a document of certification created or issued by the OSNS in respect of a matter mentioned in Section 11 about the fact that they possess a conveyance. D, any other document or thing that is certified, created, or issued in the name of OSNS. And E, a copy or reproduction of a document or thing mentioned in the set 4 paragraphs. If a person is charged with an offense under subsection 1 and falsify the said documents and other things, then they would commit an offense and they are liable on conviction on indictment to a fine of $500,000 and imprisonment of 7 years. Subsection 3 is about a defense for a person charged with an offense of knowingly possess a document or any other thing that is forged or is falsified. Subsection 4, it's about what has to be established for a defense. Thank you. Questions? Mr. Kennedy Wong. Thank you, Chairman. Section 14(1)(c) says a person who knowingly possesses a document or any other thing that is forged or falsified commits an offense. 14(3), there is a reasonable excuse. That's after a person has been charged. A person can raise a defense if they have a reasonable excuse. Can the administration give us some examples or scenario where a person can raise a defense? Because 14(1)(b), we don't have a defense for that. For a person who knowingly uses a document, we only have a defense for Section 14(1)(c). Can the administration give us some examples?
Mr. Ivan Leung, thank you. I thank Dr. Wong for his question. So, say someone picks up a forged copy of a legal instrument. This person thinks someone has broken the law, so this person takes this forged copy to the police station. So in that case, this person will have possessed the forged copy for a while, so we need the reasonable excuse, we need the defense. But when someone knowingly uses this forged legal instrument, we don't think there is any defense for that case. Chairman, I have a further follow-up question. I'm looking at Section 14, subsection 1(3). So someone is prosecuted for this offense. So someone is charged with an offense. Someone picks up a forged copy. They want to give it to the police, and this person will have possessed the forged copy. If this person has made this clear, why would they be prosecuted? Why would they be charged? This is a standard expression. We want to say that the defendant will have access to the defense we're not saying we have to wait till this person is prosecuted before they can raise the defense. During the investigation and prosecution of a criminal case, the investigation officers and the prosecutor will have to consider whether the mens rea and the actus reus are there, and they also have to consider the availability of a defense. So it's not like they prosecute first and wait for the defense to come later. That doesn't happen. Referent Peter Kun. My question has just been asked, so I won't be putting my question. Now it's my turn. My question has to do with Section 14, Subsection 2. Now, Subsection 1 says someone forges or falsifies a document or uses such a document or possesses such a document or any other such thing, they commit an offense. This document and any other thing include any other document or thing that is certified, created, or issued in the name of the OSNS. So my question is, by any other thing, are we also including phone scams or AI-generated scams, say voice cloning, or stuff made with deepfake or chatbot? Are we also covering those cases? So, does any other thing here cover stuff used by scammers to defraud people? In this case, I think Section 13 will apply, and that section has to do with someone impersonating an OSNS officer. Now, when someone makes an electronic text, now I'm saying any other thing, I'm not talking about document, I'm only referring to any other thing. So when we say any other thing, we're saying stuff other than documents. They may not be physical copies. Say a forged stamp, a forged chop, or some kind of AI-generated images, they may count as any other thing. So I think the ordinary meaning of any other thing is broad enough. Mr. Holden Chow. Thank you, Chairman. I want to ride on your question, Chairman. Subsection 2 has this to say. So we have items A through E, documents and other things specified for the purposes of subsection 1. Now, there is AI-generated content these days, so we are only restricting ourselves to subsection 2A through E, and then you have AI-generated clips or other AI-generated content. That content will not be covered here because we're not saying including but not limited to under subsection 2. We're simply restricting ourselves to 2E through E. So this is not a case of including but not limited to. Is that the case, Mr. Ivan Leung? We will rely on subsection 2D. You can think of 2D as a catch-all provision because it says any other document or thing. As long as someone makes something with technology or otherwise in the name of the OSNS, subsection 2D will be able to cover that. Secretary for Justice. So we may be talking about an image, AI generated or not. If it's an image that suggests it is in the name of the OSNS, we can cover that. The word thing is the broadest term to refer to everything. Mr. Gary Chen. I have a question about the penalty. So someone forges an OSNS instrument. Upon conviction, the fine will be $500,000 and an imprisonment for 7 years. But let's look at the crimes ordinance. For forging instruments, the maximum penalty is 14 years imprisonment. So the imprisonment here under this regulation is actually more lenient than what you see under the crimes ordinance. Why can we not have stiffer penalties? Why not have a longer imprisonment term for this regulation? Secretary for Security. We're not saying that we cannot prosecute someone for using or forging an instrument under that ordinance. Under the crimes ordinance, you have to prove the criminal intent. But here, under this regulation, possession, the act itself, will be enough for us to prosecute this person. Secretary for Justice. This is subsidiary legislation, and this is made under Section 110, subsection 2 of the SNS. So that subsection limits the imprisonment term of this piece of subsidiary legislation. We cannot go beyond the limit set by Section 110 under the SNSO. Now we move on to the next section, Section 15, obligation of confidentiality. Now, in the course of the OSNS's work, confidential information may be prepared, and disclosure of such information may prejudice national security. So we have looked at Article 14 of the NSL, which is also on confidentiality, not disclosing information on the work of the CSNS. That's why we propose this provision. We want to impose this confidentiality obligation. Anyone in possession of the information should not disclose the information. So you have two subsections. Subsection 1, anyone who knows of or receives any work-related information of the OSNS, they have an obligation to ensure the confidentiality of the information. Meanwhile, we also have an exception in mind. A person must not obtain, possess, or disclose the information unless the OSNS has made public the information or given lawful authority to that person. So we think with these two subsections, we will be imposing the obligation to keep the information confidential. And we are also setting out an exemption. Questions? Reverend Peter Kuhn. Thank you, Chairman. I want to follow up on the definition of work, as in work-related information. By information, I asked the question this morning whether a confidential document would come with a chop saying confidential. When you just say information, people know what it means. It would also be easier if you put a chop of confidential on all confidential documents. So what do we do about that? Ms. Daphne Sill. Reverend Kuhn's question is about the definition of work-related information. So we're talking about information in a broad sense. It's about information related to the work of the OSNS, and that includes correspondence issued by the OSNS. And also personal information of the OSNS officers, and also information about the properties, other forms of assets of those officers. The OSNS is a vital institution to safeguard national security in Hong Kong. The OSNS and the CSNS work together as enforcement mechanisms. Both matter. Their work-related information has to do with national security. So when someone wantonly discloses such information, that will prejudice the performance of duties by these two institutions, and that will give rise to national security risks. That's why the information needs to be kept confidential, and that's why we have Section 15. Any information of the OSNS, it doesn't matter whether there's a confidential chop on the document. If it's work-related information, Section 15 here will apply, and that's why it imposes a duty of confidentiality. So, Chairman, simply put, any document of the OSNS can be covered under this section. Correct. Mr. Chen Siu-hong. Chairman, Section 15 is about the duty obligation of confidentiality. So you have both duty and obligation. But I don't see any penalty. I put this question before. I can see why that's the case when public servants are involved, because we have the Civil Service Code where you have disciplinary actions. But then Section 15 here covers anyone, a person. This can be someone who is not a public servant. When such a person breaches the obligation or duty, what will the administration do to penalize or deal with that person, Ms. Stephanie Sill? It would depend on the circumstances, and it would depend on the kind of work-related information involved. Now, if the work-related information is state secret, protected under the SNSO, serious criminal offenses will arise. Now, when the information is not state secret, there is simply an obligation. We have to be proportionate with our offenses. So there is protection for state secrets, and then there's protection for work-related information that is not state secret. That's why we're imposing an obligation here. That for someone breaching the confidentiality obligation here, there will be a civil liability at common law. There is the duty of confidentiality. So I tell you something. Let's keep this secret, and without my consent, you disclose the information. And that causes harm. I can make a claim against you. I can apply for an injunction for what you have just done. So there is civil liability. But if the information is protected, it's state secret, then there will be criminal liability. Chairman. So this provision lays down the principle. So anyone has this obligation and duty to keep the information confidential. If the information is state secret, then the SNSO is clear on the penalties. So Section 15 here is simply a reminder. It sets out the principle that everyone has the duty and obligation. So that's the case. Anything to add? Now, if the information falls under Section 8, and that's in conjunction with Article 55 of the NSL, then criminal liability will arise. Mr. Holden Chow. Chairman, I want to confirm a point. When we were looking at the bill, that is now the SNSO, we did cover legal privilege. There was an exemption for lawyers at law firms. So when a law firm receives information from a client, and the information involves what we are dealing with here. As you know, law firms offer legal advice. Teams of people work at law firms. Will those people be protected? When we were looking at the bill for the current SNSO, we were told there would be legal privilege. So I wonder if that's also the case here. Who would take the question, please?
Ms. Siu? Thank you. Regarding legal privilege, we act in accordance with the laws of Hong Kong. There are exemptions under our laws for this legal professional privilege. Not all information shared with the lawyers or solicitors can be kept a secret. It's my turn. I'd like to ask about Section 15.2. It says that a person must not obtain, possess, or disclose the information of the OSNS. I'm referring to any information stated in subsection 1. Unless the OSNS has made public the information or given lawful authority to the person. Let me cite a scenario. If the network of the OSNS is being attacked, or if an OSNS staff sent work-related information by mistake through their mobile phones, such that person without lawful authority was forced to receive these information, will that person violates Section 15 bracket 2? And what is the consequences of that? Chairman, if the OSNS is attacked and information is released as a result to someone else, will the person receiving such information be deemed as having violated subsection 2? Well, apparently, the information is not given by the OSNS lawfully, or neither has the OSNS made public the information, but we have to look at whether there is a civil liability. If a person passively, without a choice, receives such an information, I don't think that they will be held civilly liable. However, after the person has received such information, they have to keep it confidential. If it's a physical document, they should turn it into the OSNS. However, if the information are textual, images, or messages, they should not forward it. If they do so, they may be held civilly liable. If they disclose the information, they will have violated subsection 1. But if a person passively receive such information and keep it on their computer, would they have committed an offense? That's my question. Because I don't see any penalty set out here. Secretary for Justice, I think that the key is not to forward the information that you receive. Of course, the person does not possess the information on purpose. They were forced to receive it. There is an obligation of confidentiality. A person who knows, as long as they know that they should not disclose it or forward it, they should keep it confidential, regardless of how they come to knowledge of the information. Well, because I see a disjunctive here. Obtain, possess, or disclose. So as long as you either obtain or possess or disclose the information, you commit the offense. Ms. Siu. Thank you. If because of the computer of the OSNS being hacked, you receive the information, you should know that you should not possess the information. We want to protect the work-related information of the OSNS. If you receive the information in such a way, you should delete it on your own. Thank you. There's no other questions. We have completed the scrutiny of LN 77, subsidiary legislation. Let's start scrutinizing LN 78 of the subsidiary legislation. Thank you. LN 78, Safeguarding National Security Declaration of Prohibited Place Ordinance or Order. There are two provisions to it. One, interpretation. It sets out the definition of OSNS so that people can make reference to it. Any questions? Chairman, Section 2, Declaration of Prohibited Places. A place specified in the schedule is declared as a prohibited place for the purposes of paragraph G of the definition of prohibited place in section 41 bracket 1 of the ordinance. In schedule, there are 6 places being set out. We use the address and the coordinates to show the place of the prohibited places. Mr. Tony Che, thank you. I'd like to clarify something. According to the government's paper, some of these prohibited places are temporary. Are we going to publish notice in the Gazette by way of negative vetting to delist some of the prohibited places? Under Section 42, bracket 4 of the Safeguarding National Security Ordinance, it says that the Chief Executive may authorize any person or any class of persons as a person or persons to discharge duty as a guard or sentry in respect of any prohibited place. So will the guard or sentry of the prohibited place staff of OSNS? With the guard or sentry in place, people will be easier to tell if a premise is a prohibited place. If you enter a place inadvertently, then the guard or sentry may ask you to leave. Monsieur. Thank you. First, what happens if some of the temporary office is no longer an OSNS related prohibited place? We are going to remove them from the schedule by way of negative vetting. And we will table the amendment to the Legisl again. Second, on the question about guard or sentry of prohibited places, we do have a specified officer in prohibited place. These officers can carry out duty as a guard, and that's set out in Section 45 of the SNSO. Subsection 5, specified officer in relation to a prohibited place mean a police officer or a person authorized under Section 42, bracket 4 in respect of the prohibited place. Under Section 42, bracket 4, bracket 2, it says that the Chief Executive may specify any person to be a guard or sentry in respect of a prohibited place. Regarding prohibited place, as set out by the CPSC, Central People's Government, it relates to a person assigned by the institution in charge of the prohibited place to discharge duty as a guard or sentry in respect of the prohibited place. So a police officer may be a guard or sentry. Chairman, just one comment. It's easy for us to tell if someone is a police officer, but it's hard for us to tell if someone is a guard if they're not a police officer. That's a comment. We will talk to the OSNS. You pressed again. Do you have other questions? None. Mr. Jeffrey Lam. Thank you, Chairman. The office of the OSNS is, well, the OSNS premises are designated as prohibited places. The same practice is adopted in other countries, so I think that this is a reasonable move. Apart from setting out the coordinates of the prohibited places, are we going to put in place, say, barriers or signages outside the prohibited places? Are we going to have the places guarded by sentries, for example? This will prevent people from entering prohibited places inadvertently. They may, say, enter the premises by mistake if they are drunk, for example. People like to use drones these days, and they may take photos of these prohibited places from afar. And as a result, disclose what's happening in these places. Will they commit an offense? I'd like to see clarification. We just scrutinized the Energy Efficiency Ordinance 2025. That's to exempt the OSNS and prohibited places from subjecting to such energy efficient audit. Now, the government is setting these 6 places as prohibited places. They will be exempted from undergoing energy efficiency audit. Should the administration put up notice in the Gazette if they add any premises to the list? Thank you. Ms. Siu. Regarding your first question, the declaration of prohibited places order is to set out the list of prohibited places under Section 13 of the NSOS espionage. Under subsection 2, there has to be an act, and that act has to undermine national security, and only with that would it constitute espionage. It include doing such act by electronic or remote means. So if you approach, inspect, pass over, or under the premises, you have committed the offense. If you're not talking about espionage, Section 44 may apply. It says that anyone without a reasonable excuse or lawful authority inspects, passes over, or under enters or accesses at prohibited places commits an offense. If you use long-ranging photographers to inspect the prohibited place, then you may commit an offense. If you take photos from afar, you may still be considered to be inspecting the place. Section 45 says that a specified officer may order any person not to do or cease to do an act that may undermine national security. They may also ask you to leave. That's my answer to the first question. Second, on the Building Energy Efficiency Bill, we have to look at whether it applies to mainland offices in Hong Kong. If not, then the buildings will not be affected. Ms. Carmen Khan. Thank you, Chairman. LN 78, Declaration of Prohibited Places Order. According to Section 2, it is said that a place specified in the schedule is declared as the prohibited place for the purpose of paragraph G of the definition of prohibited place in Section 41(1) of the Ordinance. When the Chief Executive make announcement, they have to make reference to Section 42(2), including the use and the owner of the premises, the information stored and processed in the premises, as well as the equipment stored therein. How can we make sure that the Chief Executive already have regards to these elements before giving the order?
Who will take the question, please? Mr. Ivan Leung. I thank Ms. Khan for her questions. Now, first, under the Interpretation and General Clauses Ordinance, it's stated that when a legal instrument says it is issued or made under a certain ordinance, then there is a presumption. All conditions for exercising this power have been met. Now, in the legislative brief, we have also explained the necessity for declaring a prohibited place for the place where the OSNS performs its duties. That's because the conditions are met for making such a declaration. The speaker is not coming through. Now we're looking at 2B, the owner or occupier of the place. That's section 42, subsection 2 of the SNSO. So let's look at the explanatory notes of the order. It's a key part of the order. So the occupier here is the Office for Safeguarding National Security of the Central People's Government in the HKSAR. We're talking about the occupier being the OSNS. So even when you leave aside other factors, the requirement under 2B is met. Thank you. Legal advisor. Thank you, Chairman. A straightforward question. As members may be aware, Legal Notice number 78 adopts the location plus coordinate approach in presenting the areas of the prohibited areas. Now, other subsidiary legislation on boundaries takes a different approach. Those pieces of subsidiary legislation also come with maps or images. So I wonder if the government will consider its approach. And can the government tell us about the principles and thinking behind adopting this location plus coordinates approach? Ms. Daphne Sill. Our principle is clarity. So in the order, you can see the address for each prohibited place. Each place is a building. Along with the coordinates, that's clear enough. We also want to make the information easy to follow for people, so we also included the maps in the legislative brief. As for the order itself, you have the address, you have the coordinates. There is no ambiguity or uncertainty with the way it's presented now. If there are no other questions, that concludes our deliberations. So I want to invite our legal advisor to confirm that the drafting of the English text for the two pieces of subsidiary legislation is also in order. Thank you, Chairman. The Legal Service Division has not spotted any inconsistency between the Chinese version and the English version for both pieces of subsidiary legislation. So my question for members and the administration is that will there be any amendment from both the administration or from members to these two pieces of subsidiary legislation? So no amendment from the administration. So this subcommittee has finished the scrutiny of the two pieces. So by way of summary, so we have come to the end. I thank members for taking an active part of the discussion. Also thank the Secretary for Justice and the Secretary for Security and their teams for supporting our work. So we have held 3 meetings. Altogether, it's more than 5 hours of meetings. So we have completed the scrutiny of the policy matters and the clauses of the two pieces of subsidiary legislation. The subsidiary legislation will better support the OSNS in performing their duties, and that will help us better safeguard national security, and that improves our legislation, our mechanisms of safeguarding national security. This can help us deal with unforeseen national security risks. The subcommittee has been highly productive, and we have examined the subsidiary legislation with care. At the 3 meetings, members raised all kinds of questions, and those questions have been addressed by the administration. The administration has allayed concerns and helped the public get a better sense of the intent of this legislative exercise and the details. Now, since the subcommittee has finished the scrutiny of the two pieces of subsidiary legislation, and we have met the goal. So, since we want to move as fast as we can, every day counts. So, at the House meeting today, or House meeting tomorrow, I will make an oral report on the work of the subcommittee. I believe members will support this idea for the House Committee meeting tomorrow. Now, if there is no objection from members, then as the chairman of the subcommittee, I will also write to the chairperson of the House Committee about making this oral report up at the House Committee meeting tomorrow. Again, I thank everyone for your effort for the smooth conclusion of the work of the subcommittee. Thank you.